Thank you, Ms. Dempsey, and on behalf of Judges Bennett and McClarty, we welcome counsel to this oral argument, which we are live streaming to fulfill our obligations to maintain open courts. Each of you has 15 minutes to present your argument, and the appellant has reserved some of that for rebuttal. As there are no announcements, I will ask Ms. Dempsey to call the case.
Cookeville Platinum LLC versus Satellite MD LLC.
Thank you, and the appellant has the floor.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Evan Rothy, counsel for the appellant, Satellite MD LLC. And the primary question before the court is straightforward. What were the boundaries of the property that Satellite sold to Platinum? Platinum placed the winning bid at auction for a re-subdivided parcel as shown through an approved and recorded survey plat. But the trial court held that based on an isolated portion of the purchase agreement memorializing that sale, Satellite actually sold the former boundaries of that property that did not exist at the close of the auction or at the time of contracting. In doing so, the trial court mishandled both the text and the context of the purchase agreement. We respectfully ask this court to reverse the trial court's rulings on the cross motions for judgment on the pleadings and the attendant awards of costs, fees, and interest to Platinum, and hold that Platinum, in fact, breached the as-is, where-is purchase agreement, remanding this case for further proceedings on interest, fees, and cost awards to Satellite. Alternatively, we ask this court to reverse the ruling of the judgment on the pleadings on the basis of latent ambiguities that require further fact-finding. In January of last year, Satellite, a medical clinic, pursued the sale of one of two adjoining properties fronting Bunker Hill Road in Cookeville, Tennessee. They negotiated a sale with their existing neighbor, Platinum, but those negotiations broke down in large part because Satellite intended to retain a gravel alley that ran between the two parcels. So Satellite put the property up for auction. The auction listing stated the property would be sold with a new deed description and included a survey plat re-subdividing the boundaries of the properties. At that auction, Platinum repeatedly placed bids, and that very same survey plat was submitted to the Cookeville Municipal Planning Commission as required by Tennessee statute, approved and recorded, and the day after that document was recorded, Platinum placed the winning bid. By making that winning bid, Platinum warranted that it had performed its due diligence prior to bidding. Several days later, the parties executed a purchase agreement, but when it came time to close, Platinum refused to close on the property unless Satellite also included the gravel alley. Reversal of the trial court in whole or in part is warranted for three reasons. First, the text of the purchase agreement conveyed the property with the boundaries reflected in the survey plat. Second, the context of contracting, including the extrinsic matters referenced in the text of the purchase agreement, elucidates the clear of the intent of the parties to convey the property as it existed in the auction and at execution. And lastly, Platinum breached the purchase agreement by refusing to close, despite agreeing to take the property as is, where is, with no contingencies, and that all due diligence had been completed.
Mr. Rothy, the trial court's decision appears to be greatly influenced by the integration clause in the purchase agreement that both parties signed after the auction. This agreement constitutes the sole and entire agreement between the parties hereto, and no modification of this agreement shall be binding upon any party hereto. How did we get around that?
Your Honor, you broke up a little bit at the end, but I believe your question was, what is the relationship between the integration of the contract and the extrinsic evidence? Is that correct?
No, how do you get around the integration clause? In Tennessee, those integration clauses are quite binding.
Your Honor, I agree, and I don't believe that there is any need to get around the integration clause. The text of the purchase agreement conveyed the property as it was at signing. Specifically the property description. In the most particular provisioning, the property was more particularly described as is recorded with the Register of Deeds of the county in which the property is located.
But the purchase agreement had a different description.
Your Honor, I disagree. The property description of the purchase agreement is one long sentence consisting of 4 different clauses. It's a belt and suspenders approach to address the statute of frauds requirement that contracts sufficiently describe the property to be sold. And so in doing so, it references several different instruments: the address that the property is known as, it references the tax map and parcel number, it references the prior granting deed, it also references and incorporates what is recorded with the Register of Deeds office. And so in so doing, it references different ways to identify the specific property. And the most specific manner is what is recorded with the Register of Deeds, which includes the recorded survey plat. And moreover, Your Honor, I would add that a contract must be read as a whole. The text of the contract is to be interpreted in light of all of its provisions. And if the court refers to the special stipulations, Platinum agreed to take the property as is, where is, as a controlling matter, and above all else. Regardless of the exact terms of the property description, there is no dispute as to the identity of the parcel. What is at concern is the boundaries of that property. And respectfully, those boundaries are not defined within the 4 corners of the purchase agreement. Those property boundaries are defined by reference to other matters that are extrinsic to the document. So extrinsic evidence is required, specifically the extrinsic evidence that is referenced in the text of the purchase agreement. And to that point, like I said, the text of the contract is determined by all of the provisions through well-worn canons of construction. The contract is to be read as a whole. There is a presumption against surplusage. When more specific provisions qualify a general, when there are several provisions referring to the same subject matter. And documents that are incorporated by reference must be considered as part of the agreement. Looking at the text of the purchase agreement, all these show that Satellite and Platinum agreed that the sale involved the property in its legal condition at the time of execution. Moreover, the context of contracting harmonizes with the text of the purchase agreement. As this court recently said in Generation 4 Recycling Group versus Triumph Aerostructures, the meaning of contractual terms can almost never be plain except in a context. So courts must construe the contract with reference to the situation of the parties. The Supreme Court has been abundantly clear in individual healthcare. Courts should not be shut out of the same light which the parties enjoyed when the contract was executed. Here, the boundaries of the property are not reflected within the 4 corners. Reference is necessarily made to extrinsic matters, specifically references made to the address, to the prior granting deed, to the tax map and parcel number, and to the records of the Register of Deeds office. All of these do not vary, alter, or conflict with the terms of the purchase agreement. They are harmonized together with that. And that harmonizes with the auction context in which this contract arose. Satellite explicitly sold the property subject to the survey plat. That survey plat was recorded, and Platinum was on constructive notice of that document when it placed the winning bid and executed the purchase agreement.
Now, Mr. Rothy, the survey plat was referenced in the auction notices, but it was not referenced in the purchase agreement, if I understand the facts correctly.
Your Honor, it was not explicitly referenced in the purchase agreement, and perhaps if it had, we might not be here today.
I'm confident of that.
But the survey plat is incorporated into the purchase agreement in 3 particular ways. First, again, reference to the Record of Deeds office, which includes the recorded survey plat. The as is, where is clause references to where the property is, the spatial condition of the property at the time of execution, which is reflected through the recorded survey plat. And the purchase agreement also contemplates that the seller will provide a survey. In this case, that was the recorded survey plat. And so while the survey plat is not explicitly referenced in the document, it appears multiple times. And as far as I'm aware, there is no law that requires explicit reference to incorporate by reference. And in fact, courts have held to the contrary, as long as the documents are part of the same transaction. Moreover, Platinum breached the purchase agreement when it refused to close on the property. Platinum warranted that it performed its due diligence before bidding, but it did not do its due diligence until prior to closing. Platinum took the property as is, where is, with no contingencies. Still, Platinum would not take the property unless it included the gravel alley. Platinum executed a purchase agreement that plainly stated that any breach would result in liquid damages in the amount of its earnest money deposit. Still, Platinum refused to close. At bottom, Platinum breached the purchase agreement. But alternatively, the document itself references various other instruments extraneous to the four corners of the document. Those documents may, in the court's holding, create a latent ambiguity as to what the boundaries of the property were. In any case, reversal of the trial court's rulings on the judgment for motions on the pleadings, disfavored rulings, is warranted in this case. Thank you, Your Honors.
Thank you, Mr. Rothy. We'll hear further from you on rebuttal. In the meantime, Mr. Williams, you have the floor.
Thank you. Good afternoon. Taylor Williams of Payne, Tar, Water, and Vickers, the Knoxville Bar, on behalf of Appellee, Cookeville Platinum, LLC. And there's been some discussion that this was a boundary dispute. And frankly, that's not correct. This is a breach of contract. There was no land that was ever sold. As a breach of contract, we have to ask ourselves, what was the promise that was made? And in this case, the promise that was made appears in paragraph 1 of the commercial purchase and sale agreement, technical record page 45, which very clearly said, and I'll paraphrase a bit, but buyer agrees to buy and seller agrees to sell all that tract of land known as 1238 Bunker Hill Road, Cookeville, Tennessee, as recorded, Putnam County Register of Deeds, book 984, page 786. There's a blank for instrument number that it remains blank, and as further described by map 66, parcel 84 in Cookeville, Tennessee, together with all of its improvements, all being hereinafter collectively referred to as the property. And simply, that is the end of the inquiry. There was a promise made to sell property as described by book 984, page 786. I'll refer to the deed as those numbers moving forward. But to sell the property as described, 984, 786. That was the promise that was made. That promise was not fulfilled. And that's ultimately what the trial court ruled. The trial court said, if I read paragraph 1, there's no ambiguity, there's no question. The plain, ordinary meaning of these words mean, I am selling you the property as described in book 984, page 786. That's it. These reasons, the trial court's ruling in favor of Platinum, returning its earnest money, granting its attorney's fees and cost, ruling to dismiss the claims brought by Satellite against it for breach of contract, was correct and should be affirmed in all courts. And it's interesting because there's now suggestion that there's some ambiguity that needs to be resolved by the trial court. But at the trial court level, Platinum filed a motion for judgment on the pleading saying paragraph 1 of the contract was clear, and Satellite made the choice to file a countervailing motion for judgment on the pleadings, also saying that paragraph 1 was clear. There is no ambiguity here. There never has been. It was not represented in front of the trial court that there was ambiguity. It was clear both parties moved for their interpretation of paragraph 1. And it's important to also keep in mind that what Platinum was asking for was the return of its money. Satellite's position was that despite the fact it never transferred this land, despite the fact that land has now presumably been transferred to somebody else, Satellite got to keep $137,000. Despite the fact that the commercial purchase and sale agreement very clearly says Satellite promised to sell land described by book 984, page 786. Satellite's position that you've just heard, if there's any position to be found in the text of the document, which is questionable, but if there's any position to be found actually in the text, relies upon this as is recorded in the remainder of paragraph 1. What's noticeable about the as is recorded language in paragraph 1 is it comes after property has been defined. Property with a capital P defined term has been defined to say book 984, page 786. The remainder of the contract, the entirety of the contract, deals with capital P property. And so what Satellite's position is suggesting is that after the parties went to the trouble to list an address, a book and page, and express reference to a document, they chose to leave blank an instrument number, then refer to a tax and parcel map, and then say, this is the property. They then went to the trouble to say, oh, by the way, just whatever's on file over at the Register of Deeds. Forget everything that we just listed, all of that specificity, all of that detail, all of those express reference. Don't worry about those. Let's just go see what's on file over at the Register of Deeds, and that's what I'm actually selling to you. That's an absurd reading. More than just being absurd, though, it results in a direct contradiction, not in the contract in its entirety, but in a specific provision. In fact, in a single sentence, Satellite's reading would create an ambiguity, or not ambiguity, I'm sorry, a contradiction, would create a contradiction where the parties agreed to a property by the description, book and page, and then said after that, but a different book and page. That one sentence would contradict itself. And as all the parties agree, you cannot if there's multiple interpretations of a contract provision, you cannot accept the interpretation that results in contradiction. Platinum's interpretation, on the other hand, simply says that that is a reference back to the book and page, the deed that has already been expressly identified. Platinum's position is that the as is recorded is 984-786. It causes the entirety of paragraph 1 to be read in harmony. It frankly makes common sense. It applies the common and ordinary and natural meaning of these words to the contract. And while this may not be a legal reason, it seems good to me that if you handed this document to a person on the street, they could pick it up and know exactly what everybody was talking about. No one has to go down to the Register of Deeds. They could see it right there on the document. Satellite's position is to create contradictions based upon documents that are not referenced. Which brings to the second reason why this as is recorded language it misses the mark, is that the survey plat isn't actually referenced. To incorporate by reference, you need to reference something. And there's many ways that something can be referenced. For example, the deed 984-786 was referenced by its book and page. There's no dispute that the survey plat had a book and page. They could have used that. There's no dispute the survey plat had an instrument number. They could have used that. That's blank. There's an actual blank in the document that says as further described, where you could write in anything you wanted to. They could have written in the title of that survey plat. They could have written in the date the survey plat. They could have written in the surveyor, the lot number. They could have written in anything at that point in time to actually reference a document. But none of that took place. There was no reference at all to the survey plat. And the suggestion that just whatever's on file over there must mean the survey plat inserts new words and new meanings into the purchase agreement that does not exist. Satellite used in its briefing all that is recorded or the last recorded. None of those terms actually appear anywhere in the purchase agreement. The third reason this as is recorded argument fails is because it is based upon the premise that it is more specific over general to say that this as more particularly described in Exhibit A. That's an incorrect reading for multiple reasons. First, general versus specific only applies in the event of a contradiction of the terms. As mentioned before, Platinum has a reasonable reading of this document where there is no contradiction. We do not have to ask ourselves what is general and what is specific. There is no contradiction. Second, the as more particularly described is separated by a disjunctive or. And the phrase actually reads that to define the word property, comma, as is recorded with the Register of Deeds. The as more particularly described only deals with Exhibit A. It does not deal with the as is recorded. Finally, there is no dispute that book 984, page 786 is a warranty deed, that it has a specific description of the land, which again, there's no dispute between the parties that includes this gravel driveway, which ultimately became the primary issue. There's no question about the meets and the bounds. There's no question about the sufficiency of the description there. There's not a general versus specific. There's the document I want versus the document that you want. And unfortunately for Satellite, the document that Platinum wants is actually expressly referenced in the purchase agreement. So for that reason, this idea that what comes after the term property is defined is somehow superior, has a super priority, is not supported by any canon of contract interpretation and is plainly not supported by the simple language of the document. Apparently an implicit acknowledgement that paragraph 1 of the purchase agreement does not support Satellite's position. There is a whole mountain of parole evidence that was presented to the trial court, that was presented in the Satellite's briefing to this court. And that parole evidence cannot be used as Satellite is attempting to use it. Individual healthcare specialist, as everybody knows, is the controlling case on this matter. And while it goes through a long roundabout description of contextual and textual jurisprudence in the state of Tennessee, when it gets to the end, it says we're going to kind of sidestep all of that and say the one thing that has been clear for centuries in Tennessee jurisprudence is that the parole evidence rule will not allow, in a fully integrated document, a party to change a written term based upon parole evidence. And the Supreme Court tells us you have to ask yourself is how is that parole evidence being used? It's not what is the parole evidence or those issues, it's how are you using it? Similar to we ask ourselves in a hearsay question, how is the hearsay being introduced? And so how is this parole evidence being used? It's being used to delete, no matter what the evidence is, in any form, it is being used to delete 984-786. At the end of the day, that's all they want. All Satellite wants is to get rid of 984-786. And that is the one thing that, despite a century of meandering jurisprudence that the court tried to reconcile an individual healthcare specialist, that it said this has always been clear. And it's been clear for a century, and it's clear here. When the document says 984-786, that's what the parties meant. And you can't use parole evidence to change that after the fact. And that's what they're trying to do. Satellite is simply trying to rewrite the document. In a last-ditch effort, Satellite points to this as is, whereas clause. It appears in paragraph 17, the technical record, page 51. And it's important how paragraph 17 starts. It says, the following stipulations apply, and I'm paraphrasing again, if there's a contradiction, these stipulations control. And so Satellite uses that language suggesting that it controls over the prior language to say, this as is whereas clause supersedes. That's incorrect. As is whereas, that there has to be a contradiction. And at no point in time does as is whereas state that the property description has changed or should have changed. In fact, paragraph 17 refers to the property, which again, I know I've beat this horse at this point in time, but the property was defined earlier in paragraph 1 as book 984, page 786. So it's saying the property, 984, 786, is being accepted as is whereas. And there is no dispute that Platinum was accepting that property as described by 984, 786 with warts and all. There's no dispute. That's how they would have received it. But they had to receive the property as it was defined. And it was defined by book 984, page 786, as clearly stated in paragraph 1. So this as is whereas clause, you have to ask yourself as what is, where what is. And the what is the property, which is a defined term that we've already covered. Moreover, from a policy standpoint, allowing an as is whereas clause to have that wide-reaching implications would, as we put in our briefing, allow a party to file a deed at the very last second, even during closing, and that deed would control, because the contract just says, well, you accepted it as is, that means whatever's on file. That obviously would be an absurd result. It would also result in the parole evidence rule essentially being eviscerated. You cannot say that the as is whereas means you get whatever I told you that's what I was going to sell to you, despite the fact that the document says something else. That is a position that is untenable in Tennessee jurisprudence. For all of these reasons, Platinum asked this court to affirm the trial court in all respects. The trial court correctly found that paragraph 1 was clear and unambiguous, that the language could be applied in a plain, ordinary reading, that Satellite promised to deliver a piece of property with a description similar to book 984, page 786. That Satellite refused to do that. As a result, Platinum was entitled to the return of $137,000 in earnest money. It was entitled to an award of attorney's fees and cost. It should be entitled to an award of its attorney's fees and cost on this appeal. And Satellite's countervailing claims against it should be dismissed. And I believe I have a little time left, so if there are any questions, I'd be happy to answer those.
Hearing no further questions, thank you, Mr. Williams. We'll now hear rebuttal from Mr. Rothy.
Thank you, Your Honor. First, I'd like to address the treatment of the alternative argument that Satellite put forth both before the trial court and this court, and then turn back to our primary argument. Opposing counsel just stated that at no point has Satellite before the trial court asserted that there are latent ambiguities. That is incorrect, and we refer the court to volume 2, pages 197 to 203 of the technical record, which contains the response of Satellite to Platinum's initial motion for judgment on the pleadings. Therein, we argued that there are latent ambiguities in the contract. This issue has not been waived, and this is not raised for the first time on appeal. And as a telling point, opposing counsel has mentioned that if consideration of the records of deeds office is given, there could be a conflict or an ambiguity, quote, as between the prior deed and the records at the Register of Deeds office, perhaps conceding that there is the prospect of a latent ambiguity. But Your Honors, we assert primarily that there is no ambiguity in the text, that Satellite conveyed the property as it was at the time of execution, as it was through the auction. Now, opposing counsel has stated that the entire inquiry ends after reference to the tax map and parcel. In other words, we must excise the entire remainder of the contract when considering the intent of the parties. Respectfully, Tennessee law rejects that position. Contract interpretation is not a divide and conquer effort. First, looking to the position, there's a false conflict being presented as to the survey plat and the prior deed. A property is built by an accretion of sales of various instruments that deal with the property. If a reference is made to a prior grantor to a prior grantee, that property is still clearly identified. So if the property did not go to Satellite's granting deed, but referenced a prior granting deed, there would be no question as to the identity of the property at hand. In a deed, this is referred to as a derivation clause. It shows the chain of title so that a party can do its due diligence, can identify what is at hand. But Platinum asserts that if a prior granting deed is referenced, no intervening actions with regard to the property can alter what is for sale. By that logic, no easements could have occurred between Satellite to receive the property and sale to Platinum. If there were any easements, those would be eliminated by the reference to the derivation through the derivation clause. This is an absurd position and comes to absurd results. And again, this reference, like I said, the property description is a belt and suspenders structure. Long jurisprudence of Tennessee law explains what is required to describe a property. So this particular contract uses several vehicles. And last, it refers to what is recorded with the Register of Deeds. Now, Platinum referenced in its briefing Archer, saying that a reference to the prior deed, Archer versus, can't remember the second party, but it referenced that a reference to a prior deed was the sole description. But in that property description, there was only a reference to the prior deed. Looking instead to Akins v. Tedder, which references a prior case under Tennessee law, several items were referenced to describe the property. And the most specific description was what was recorded with the Register of Deeds. The court held that that was sufficient to describe the property. There is no excision of the reference to the Register of Deeds office. It is not extraneous to the document. The contract must be read as a harmonious whole. Either the deed, the prior granting deed, stands alone to the exclusion of all else, which is what Platinum suggests to this court and suggested to the trial court, or all of the elements of the property description, one long sentence, are considered together. Again, we do not assert that the survey plat and the prior granting deed are in conflict with one another, as again, the identity of the property was being set out in the property description. Likewise, Platinum attempts to excise the as is, where is clause from the contract. In order to determine that as is, where is doesn't matter, one must look again only to the prior granting deed. Myopically focus on the single instrument referenced in a whole contract. But an as is, where is clause has legal significance. Platinum cannot discount it by asserting that a separate reference wholly subsumes this document. As a controlling matter in the special stipulations, the parties agreed the property was being sold as is, where is, the spatial legal condition at signing. This is reflected through the recorded survey plat. We respectfully ask this court to reverse the trial court's rulings on the judgment on the pleading motions and remand this case for assessment of costs and fees or for further proceedings. Thank you, Your Honors.
Thank you, Mr. Rothy and Mr. Williams, for your arguments. We will take this matter under advisement. Ms. Dempsey?
This honorable court is in recess until 3 p.m.
Thank you. And counsel, you are free to exit the meeting.
Thank you very much.
Thank you, Your Honor.